Companies Act, Section 360, Powers and Functions of the Official Liquidator. Section 360 of the Companies Act, 2013 lays down the legal basis for determining the powers and functions of the official liquidator, a central figure in the winding-up process of companies ordered by the National Company Law Tribunal, NCLT. This provision empowers the official liquidator to perform a wide array of duties and responsibilities as may be prescribed by the central government, while also enabling him to act with powers similar to those of a company liquidator appointed under other provisions of the Act. Additionally, the section entrusts the official liquidator with the authority to conduct inquiries or investigations, thereby equipping him with quasi-investigative functions where necessary. The intent of this provision is to ensure that the winding-up process is professionally administered, transparent, and conducted under a strong regulatory and procedural framework, with appropriate oversight by both the central government and the tribunal. 1. Statutory source of powers and duties. The official liquidator shall exercise such powers and perform such duties as the central government may prescribe. Explanation and key points. This clause serves as a broad enabling provision, giving the central government the authority to determine the scope of powers and duties that the official liquidator may exercise in the course of discharging his responsibilities. The phrase, "as the central government may prescribe," implies that these powers and duties are to be specified through rules, notifications, or regulations, and can be updated or modified from time to time. Such delegation of authority ensures administrative flexibility, allowing the government to tailor the responsibilities of the official liquidator to evolving legal, commercial, and regulatory environments. The uniform application of powers across different jurisdictions and winding-up cases. The institutionalization of the liquidation process with procedural clarity and control. 2. Supplementary powers of the official liquidator. This provision further clarifies that the official liquidator, in addition to the powers prescribed by the central government, is also empowered to act under certain additional authorities. 2. A. Powers of a company liquidator. The official liquidator may exercise all or any of the powers as may be exercised by a company liquidator under the provisions of this Act. Explanation and key points. This provision allows the official liquidator to act with the same legal authority as a company liquidator appointed under other winding-up provisions of the Companies Act. This includes, but is not limited to, powers such as taking custody and control of all assets, books, and records of the company, realizing the assets of the company and applying them toward the payment of debts and distribution among stakeholders, calling meetings of creditors and contributors, carrying on the business of the company if it is beneficial for winding-up purposes, instituting or defending legal proceedings on behalf of the company. This equivalency ensures that the official liquidator is not procedurally handicapped in comparison to a privately appointed company liquidator and can function with full authority to ensure an effective winding-up process. 2. B. Authority to conduct inquiries and investigations. The official liquidator may conduct inquiries or investigations, if directed by the tribunal or the central government, in respect of matters arising out of winding-up proceedings. Explanation and key points. This clause grants the official liquidator investigative and quasi-judicial functions, reinforcing the regulatory oversight aspect of the liquidation process. Such inquiries may involve scrutiny of fraudulent activities, misconduct, or misfeasance by promoters, directors, officers, or any person connected with the affairs of the company. Investigation into unrecorded liabilities or untraceable assets. Examination of preferential transactions, undervalued transfers, or attempts at evading creditor claims. However, this authority is not self-executing. The official liquidator must receive a specific direction from either the tribunal, NCLT, during the course of the winding up proceedings, or the central government, acting in its regulatory capacity. This ensures that such powers are exercised judiciously and with oversight, to prevent arbitrary or excessive investigative actions. For more details, contact us.